Continuing Avery pretrial, State of Wisconsin, Circuit Court, Manitowoc County, Branch 1. State of Wisconsin Plaintiff versus Stephen A. Avery, Defendant. Motion hearing, case number 05CF381. Date January 4th, 2007. Before the Honorable Patrick Willis, Circuit Court Judge. Appearances, Kenneth Kratz, Norman Gunn, both special prosecutors on behalf of the state of Wisconsin. Dean Strang and Jerome Beauty, both attorneys at law on behalf of the defendant. Stephen A. Avery, defendant, appears in person. The court. At this time, the court calls State of Wisconsin versus Stephen Avery, case number 05CF381. This matter is scheduled this afternoon for a hearing on a motion that was filed yesterday by the state, specifically a motion to exclude blood vial evidence or, in the alternative, to analyze the vial of blood. Will the parties present state their appearances for the record, please? Attorney Kratz. The state appears by Calumet County District Attorney Ken Kratz, appearing as special prosecutor. Norm Gunn also appears as special prosecutor. And I should alert the court that this is Mr. Gunn's motion. Attorney Strang. Good afternoon. Stephen Avery is here in person this afternoon. Jerome Beauty of Beauty and Williams appears on his behalf, as do I. Dean Strang of Hurley, Burrish, and Stanton. I think that covers it. The court. All right. I will indicate for the record that I received by fax. It probably came in last night. I read it this morning. That is the state's motion and the memorandum that was submitted in the support of the motion. I have also received and read the defendant's response to the state's motion to exclude the blood vial evidence. I will give the parties the opportunity to briefly supplement the memoranda with an oral argument, if they wish. Mr. Gunn. Attorney Gunn. Thank you, Your Honor. I believe that the court can make an analysis under the cited cases in our brief of State v. Richardson and State v. Denny. The state will concede that there may be some relevance to this vial of blood to this trial, but I think that the analysis must be further by the court and to look at the probative value of this and to make a determination under 904.03 whether this would be a delay of the trial, confusion of issues for the jury, and this complete analysis must be done by the court. I note from the response by the defense that at no time do they suggest or state that this vial of blood is admissible, and I believe that under the case law that the court should rule that this is inadmissible evidence for those reasons. Conceding that there may be some relevancy, I believe that the probative value is very low. And if one makes an analysis akin to the analysis the court made in Steve v. Richardson, you have to look at all the assumptions that a jury is going to have to make about this vial of blood. Now, I'm making these assumptions along a Richardson analysis, knowing that the defense has not filed or given any type of offer of proof of how they plan to connect the vial of blood to Teresa Halbach's SUV. But the jury is going to have to make assumptions that the blood in the vial is Stephen Avery's. They're going to have to assume that it was planted at some time between November 3rd and November 5th, or if maybe it was planted on October 31st or November 1st or 2nd. But that type of assumption implies that perhaps a police officer murdered Teresa Halbach and cut up her body and planted this to try and frame Stephen Avery. They would have to assume that the police or whoever planted it knew that Teresa Halbach was dead. And how could they know that? The only way they could possibly know that would be if Stephen Avery told them or Mr. Dassey told them, and Mr. Dassey didn't say anything until March 1st, or one of the police actually did the killing and perhaps got an anonymous tip. But there are so many factors out there and so many assumptions that would have to be made, and this lends itself to confusion of issues and misleading the jury and really a purposeful attempt to distract their attention from the focusing on the true issue in this case, and that is whether Stephen Avery murdered Teresa Halbach. But there's also going to have to be assumptions made that some law enforcement officer had access to this vial of blood somehow, or was there complicity by the clerk of courts in Manitowoc County, or was it just This isn't a case of negligence we're talking about, an intentional crime committed by law enforcement officers and possibly along with the clerk of courts. This is an appalling allegation that's being made. And there's so many assumptions, as I said, would have to be made by the jury that I believe that this is a very low probative value to this evidence. And when you have a low probative value to the evidence, the analysis is under a 904.03 examination certainly shows how this would be such a waste of time and confusion of issues and distraction to the jury. Because the court, I believe from the prior ruling, especially when we argued the 904.04b, other acts, other wrongs and crimes evidence, the court wants this trial to focus on whether Stephen Avery murdered Teresa Halbach and not to get sidetracked on other issues and collateral issues. But if this vial of evidence comes in, it is just fraught with other issues such as, is it Stephen Avery's, who drew it, what happened when it was at the Laboratory Corporation of America, who had access to it, what are the security procedures at the Manitowoc County Clerk of Court's office. There are just so many side issues and collateral issues that I believe that it necessitates under a 904.03 analysis that this evidence lacks, number one, probative value, and also would be a waste of time and confusion issues for the jury. But we ask this court to not allow this evidence to come in. I also want to address, I guess, sort of a presumptive strike. I would like to make on this knowledge on our part, the state, and our access to this vial of blood, and the untimeliness of the notifying us about the existence of it. I want the court to know that the prosecution team, I believe, exercised due diligence in looking for this vial, a vial of blood. We recognized this early on and asked our detectives to search for it. We would have searched in all the places that one would expect to find a vial of blood: crime labs, Manitowoc County Sheriff's Department, law enforcement, and as I said, we exercised due diligence in looking for it. This vial of blood turns out to be in existence, but there's really few people who knew about it. It was never in the control of law enforcement. And to try and associate Manitowoc County Clerk of Court's office with law enforcement is a stretch. This is a public service. They serve the public. These are people who have taken, I imagine, an oath of office, and they have jobs, civil and criminal, and all the other things that go along with the clerk of courts. They are not associated with law enforcement at all. And I was very surprised to see that a vial of blood to turn up there. But we did look, and we looked and tried to find it, because we felt like that if they want to pursue a planting defense, fine. But how do you plant evidence if there is no blood? Now they've come up with this, but this information that was in the possession of Mr. Avery, he could tell them, hey, blood was drawn from me up in Fox Lake or wherever it was in 1996. And this is also an Innocence Project case. And that is something I think the defense is more aligned with than the prosecution are aligned with. And they had more of an opportunity to know and to find out the existence of this vial of blood. And they knew about it at least in July 20th. It could have been earlier, but I believe if they viewed it so importantly and wanted it sealed, they should have told us about it. I think they had a responsibility under 971.23, the discovery statute, to tell us about this and give us an opportunity to test this, because this is the crux of the case, this vial of blood now, and we need to meet the defense and have the opportunity to test this vial to meet their defense. And the defense in this case, and I just want to reiterate to the court that you're talking about people's reputations here. There's an allegation that they're going to be made by the defense, and they have made them already, that perhaps some law enforcement officer, someone from Manitowoc County who is sworn to protect the public, to serve the public, took this vial of blood and so callously disregard for the Halbach family, planted this evidence in a car and didn't care who murdered Teresa Halbach. This is appalling. This is a despicable defense. Also, they are saying that someone in the Manitowoc County Courthouse, whether it be through complicity or slipshod operations, that this place was just wide open for anybody to willy-nilly walk in and get access to it. and that's not what I found when I visited the Manitowoc County Clerk of Court's office. I didn't find that at all, and it's just a despicable allegation and defense, and we need to meet it, Your Honor. We need to meet it full on. And I'm asking the court first to rule under a Richardson and also a Denny analysis. How is the defense going to connect the vial of blood in Manitowoc County Clerk of Court's office to the SUV of Teresa Halbach? And how do they make that connection? Just by saying so? Just saying so it exists? I mean, you could make that same argument that if Mr. Avery donated blood, or was taken for medical procedure, or blood was drawn for a myriad of reasons, that just because it exists, therefore somehow under all possible scenarios, the blood was taken by someone and planted in the SUV. The connection is there. It is not there. They have met it under the Denny or under the Richardson analysis, so it should be excluded. But if the court does not wish to exclude it, we ask the court to allow us time to test it, and we want to test it with the FBI. That may take 3 to 4 months to test it, so we would be asking for a continuance. And the other concerns that we have are that many potential appellate issues that could come up, especially under Hicks, Moran, and Armstrong analysis, on whether it be in the interest of justice or ineffective assistance of counsel. There is evidence, a blood vial that can be tested chemically, that can be scientifically tested. And it can tell us whether the blood in Teresa Halbach's car came from that vial of blood. And I believe that this case is too important. We have come too far, too long, and too many vicious allegations against people who were public servants or law enforcement officers have been made that we must have the opportunity to have that vial and do testing that we believe is suitable to meet their defense. May I have just a moment, Your Honor? The court, go ahead. Attorney Gahn, that's all I have. Thank you. The court, Mr. Buting, or I got the brief from Mr. Buting, or is it Mr. String? Attorney Buting, we both may respond at different times depending on issues that come up, but Mr. String will take the lead here. Attorney String, one of the good things, Your Honor, that 800 or 900 years of history with the English common law coming across the Atlantic to the United States has done for us is to make combat in a courtroom ritual. And when the language becomes very charged and the emotions become very charged, as inevitably they will in case which most serious, horrible, and heinous crime is alleged, it's good to have this tradition of civility and ritual control of combat to fall back upon. And I agree that the potential implication, as opposed to the allegations that we made, because we have made very few allegations, we have tried to present the facts at this point and to explore things that we have found in the Manitowoc County Circuit Court. But I agree with my friend, Mr. Gahn, that the potential inferences from this are indeed despicable in the sense of being unspeakable, in the sense of being horrible, and in the sense particularly impossibly true. And I go back to the starting point here and noting the allegations that Stephen Avery murdered Teresa Halbach are despicable in the very same way. The allegation that he had sex against this young woman's will with her are despicable and vicious in the very same way. And unlike every law enforcement officer of Manitowoc County, Mr. Avery doesn't go home at night while he's under these sorts of allegations. Presumed innocent though he may be, he sits here today in custody. And in large part, the issue that the state raises now, the court already has addressed. After a thorough briefing from both sides, briefs filed in June, states may have actually been filed in May. I don't remember. I know our response to the state's motion to prohibit evidence of third-party liability was filed on or about June 26th. And the court has ruled on July 10 of last year just exactly what the disclosure obligation was on the defense for extrinsic evidence of planting, has ruled on what inferences we might pursue or argue with that extrinsic evidence of planting. And I'm glad to hear this afternoon that counsel for the state does not reiterate the written argument made yesterday that our disclosure was untimely under the court's orders. Because by the time this court was set a schedule on July 10 for disclosure of this sort of evidence, the trial had been moved to October 16th. That meant July 10th set a September 16 deadline. Long before that deadline arrived, August 22nd arrived, and the trial was moved to February 5th. And after a very thorough discussion and disagreement to be worked through, and an exchange of drafts going round and round and making at least 2, maybe 3 trips between Mr. Buting and the defense investigators in Manitowoc County Circuit Court, we decided to disclose this extrinsic evidence, or arguably the extrinsic evidence of possible planting of Stephen Avery's blood, to the state. Not 30 days before trial, as the court orders requires, but 60, and not to pursue this as ex parte, as we had intimated in chambers we were considering at one point, but to pursue it in open court in an unsealed fashion with service upon our adversaries. Those weren't easy decisions, but the fact is that disclosures were not just timely here. It was 30 days before the deadline that the court set after considering exactly the Richardson argument and the Holmes versus South Carolina argument, to which Mr. Gahn harkens back today. The issue, as I understand it here, primarily is disclosure, and now where do we go from there? To the extent that the state is arguing to exclude evidence of possible planting, the court's ruled on that. I don't know, unless there are questions from the court, that there's a need to revisit the briefing and the rulings on that earlier, particularly since the timing of disclosure now ought to be resolved, because we more than comply with the court's timing order. The vial clearly will be admissible. Its availability and proximity to members of the Manitowoc County Sheriff's Department comes in on undisputed facts to the extent of the location of the clerk's office, the location of the Sheriff's Department, the location within the clerk's office of 2 boxes of cartons that contain the 1985 Avery file. And the 904.03 analysis, I think, benefits in a sense from stepping back just a little bit, and again, understanding that from a beginning, counsel for the state has estimated, as I recall, that it would take 3 to 5 weeks to present the state's case in chief against Mr. Avery on the despicable allegations that the state hopes to prove, and that perhaps a week would be sufficient for the defense case in chief in responding to those allegations. Now, recently, the state has suggested that if there are some stipulations from the defense, this may be 4 to 5 weeks as a type for the state's case in chief. And I will say this, 1 week is still adequate or better than adequate for the defense case. So if we're going to have a discussion about all the linkages that would have to be made and all the witnesses that would have to be, who would have to be called, the balance is clearly here tips in favor of the defense and against an argument this is collateral or a waste of time. This evidence goes directly to the integrity of some of the most damning evidence against Mr. Avery and the state intends to offer. And that's the very small amounts of his dried blood that the state will now say were found in Teresa Halbach's Toyota. He's been here saying from the beginning to anybody with a microphone and a TV camera, initially in early November 2005, that if his blood was in the Toyota, somebody planted it. So that hasn't been any secret about his defense and his view of the facts. We, as his agents, to a large extent, played the hand that he dealt us, looked down the road to which he pointed us. The state didn't look in the same places we did, alters not one bit this irrefutable fact. The evidence here uncovered in the Manitowoc County Circuit Court and the Clerk of Court's office was as available to the state or to a member of the public as it was to the defense. I don't know that I'm going to go further on arguing admissibility because that's not primarily what we're here for today, but I want to address the matter for further testing on adjournment. I think Mr. Buting is better equipped to speak to the specifics of possible testing. We have tried and failed to get him, Stephen Avery, out on bail. It's been 14 months. It's been solitary confinement, and it's been under conditions that were taping of his every word, other than to cancel for one reason, has been used assiduously for the other reasons of gathering evidence by the state. And if he is to remain in custody, we will and do oppose the adjournment of this trial. We want it to go forward on February 5th if he is to remain in custody. Now, the question of the state's ability of interest in testing can be separated from an adjournment. And again, after we're talking about with Mr. Buting and his conversation with Mr. Gahn, who is candid and accessible adversary, we believe that the blood in the vial was found in the clerk's office can be partitioned, divided in a way that it does not prejudice the defense that would allow the state to undertake the testing it seeks to do. I am assured by Mr. Gahn, and I accept his word entirely, that moreover, even the very small amounts of dried blood in the Toyota RAV are sufficient to allow partitioning or to allow testing by the state without full consumption or spoliation of that dried blood evidence. I take him at his word. He is an expert in the area of blood and DNA. So I think, as a matter of testing, that the court can fashion conditions that do not prejudice Stephen Avery, that would allow the state to pursue the course of testing, any course of testing it may wish. The admissibility or relevance of the results of that testing I cannot address, and the court cannot address at this point. Nobody has briefed it. We know very little about the proposed EDTA testing. The track record of admissibility and case law is not good, but is also not terribly extensive. But again, this is a separable issue in the sense that testing can go forward. Admissibility and the relevance of the issue of results of testing or opinions formed on the basis of testing can be addressed later when there's more factually to work with. But if the state wants to test, and if Mr. Avery is to remain in custody, the trial ought to go forward while the testing process is going forward. If Mr. Avery is instead to be released on stringent conditions that would assure the community safety and reliability, remove any slight risk of flight he may represent, then the calculus changes entirely for the defense. We would not oppose an adjournment under those circumstances. We don't pursue testing ourselves. We don't know that we will. We aren't asking to, but we understand why the state wants to pursue the testing. And we also understand that the potential ramifications, largely unknowable now, but certainly imaginable, of testing results that might cast doubt about a verdict previously rendered in this case. So if this man could go home at night, as law enforcement officers do, as the rest of us do, with a GPS bracelet on his ankle, or checking in every day with the Two Rivers Police Department, or whatever conditions are like that to send him home, we would not oppose the state's request for an adjournment to test. We may well oppose in the end admissibility, the relevance of those test results, but that again is something the court could address with the benefit of knowledge of the test results, presumably, and a chance to look at the type of testing that was done, protocols, and what the case law may have to say about the admissibility of similar tests. We have not sought defense testing at this point ourselves because, as Mr. Buting said, the last time we were in court, we don't know of the test that can be done that would be productive or helpful. A federal decision from 2005 that Mr. Buting uncovered has a federal judge writing in her decision that FBI stopped doing the very testing that Mr. Gahn now says the FBI will do. Mr. Gahn's information is fresher, and again, this is a man who knows what he's doing and is candid, but our best information had been that the FBI wasn't in this business. Mr. Buting can address the other lab that the state identified as being possible site for testing, and I have no basis on which to dispute the state's assertion that there are in this whole country but 2 laboratories capable presently of doing this testing, the FBI and a private laboratory the state has named realistically. For those reasons, Mr. Buting can address the private laboratory may not be a good choice for either the state or the defense. So I hope I have been clear. I understand why the state wants to test. If the presumption of innocence that he enjoys were ungirded and backstopped here by letting him sleep where innocent people, or presumptively innocent people, sleep, we would not oppose an adjournment. The court may deny that adjournment for its own reasons, but not over our objection. If bail were modified as so that he didn't spend more months after 14 in jail, presumptively innocent, in solitary confinement, and with his every word to his loved ones listened to by police for potential evidence. If that state of life is to continue until he is tried, then Stephen Avery opposes an adjournment, thinks that testing could go forward without prejudice to him, but reserves the right to challenge or support conceivably admissibility or relevance of test results, and opinions flowing from those test results. And I'd like to turn it over to Mr. Buting to give the court a little bit better sense of why the 30-day testing option for the private lab may, in the end, not be feasible for either the state or the defense. The court, Mr. Buting, Attorney Buting. Judge, just to give you a little bit of background, I looked into this. And part of what we were doing when we discovered the possibility of that Mr. Avery's blood vial may be in the clerk's office, and recall that all we knew was that there was a box that said it was in there. The books we did not open until the court granted permission in December. But in my research, it did not appear that there was a credible lab available to do the kind of testing that Mr. Khan now says that the FBI is doing. And I don't know anything about their protocol and whether this is credible or not. But what I do know is that this kind of test he is talking about, this EDTA test, to be able to try and measure whether there is a preservative that is found in blood vials, certain blood vials, whether that can be detected in a blood stain at a crime scene, never came up until the middle of the O.J. Simpson trial, at which point the FBI, for the first time, while the trial was going on, developed some sort of testing protocol. Their expert was called, actually by the defense in the O.J. case, and was very helpful to the defense, and ultimately very, very embarrassing to the FBI, who was part of the whistleblower allegations and the very lengthy investigation that the FBI lab did of misconduct or negligence or sloppy practices in their lab. And that analyst who had testified about the EDTA test was called to task for that very testimony and that very test. Since that case, very few cases have gone forward where it's almost, in fact, it is always the defense that seeks to use this kind of test to determine, and in most cases I think it's been post-conviction, but to determine whether or not blood may have been planted that was found at a crime scene. The alternative lab that the state mentioned in their motion, National Medical Services, located in Willow Grove, Pennsylvania, has been severely discredited, and for that reason, we didn't come to court and ask that they do such a test. The federal case that Mr. Strain was referring to, for some reason I could not find on Westlaw, but it is in the public record. It is on the website, PACER website, for the United States District Court in the Southern District of California. It's Kevin Cooper versus Jill Brown, Warden of San Quentin. And the district court judge issued a very thorough 160-page decision describing the protocol that was used for EDTA test in that case. About 26 pages of the 160 concerned that one issue, the EDTA protocol, how it was devised. There were affidavits filed by the FBI in that case. That federal judge says in a forensic footnote that although the FBI had been testing during the O.J. Simpson case, they were no longer in the business of doing EDTA tests. So when I say that, my knowledge was that really there was nobody credible still doing these tests, those kinds of tests. The court, what's the year of that case? Attorney Buting, the decision came out in June of 2005. I didn't copy the whole 160 pages, so I don't have that, but the case number, the local case number is 04-CV-656, and I have a PDF I could certainly forward to the court that I was able to download from their website. In that case, the defense used Dr. Ballard from the National Medical Services, and he was so severely discredited by not only this court, but a prior court, New Jersey versus Pompey, that I just want to read this so that you realize that, frankly, that the alternative is not on the table as far as I can see from either side to try and submit this testing to there. What the court found in Pompey, as repeated in this Cooper case, is that Dr. Ballard's analytical methods were haphazard and unreliable. In some, he used valid science, gas chromatography, mass spectrometry to obtain a product, glibly and unscientifically dismissed EDTA sources other than the purple top tubes, and took a gargantuan leap to a conclusion that is unsupported by science, facts in the record, or even common sense. Ballard skewed the presentation of his data, obscured the significance of his findings, and changed his hypothesis to suit the defendant's tampering theory. Ballard did not demonstrate that his conclusions were predicated on a reliable foundation. Rather, his constant equivocations discredited his method of reasoning and thus rendered the ultimate conclusion worthless. So I just say that, so it's very clear that I do not see that lab of any sort of option on either side, and therefore we're left with, if Mr. Gahn's information is correct, I have no reason to doubt that his information apparently is now that the FBI is back in the business of doing this. I don't know how they do it, and I would certainly reserve the opportunity to challenge the reliability or methods of protocol that they use, and may want to discuss with the court further how that should be done if testing is granted. But clearly the FBI is the only option, so I can understand why is that the state's preference. Thank you. The court, Mr. Gahn. Attorney Gahn, just briefly, Your Honor, I think that you can see that the defense at least agrees that there is something important about doing this testing, that traditionally it's been suggested by the defense and has generally come up in post-conviction motions. The FBI does do this testing. I spoke with him on a number of occasions. Yesterday was the latest that I spoke with the chemist, toxicologist who would be doing this testing for us. I do not, as I stated in the brief for the court's information, I said that there were two places. I do not care to send it to National Medical Services. We want to send it to the FBI. That's where I believe the history and the experience and the methodology used by them will be to our benefit, should there be an admissibility hearing down the road. But I think the defense recognizes the importance of doing this testing, and if, as they say, this vial of blood goes to the integrity of our evidence, we have to test it, Your Honor, and we have to test it at a credible, meaningful laboratory. I don't think that there's any way around this. We either test it now or we test it later. And the cases, I believe, under whether it be ineffective assistance of counsel or whether it be in the interest of justice, it's going to be tested later. That's my belief. And I think that the history of these cases in Wisconsin indicates that it would be prudent to do it now instead of later. The court, do understand that although the National Medical Services Laboratory is mentioned in your brief, that you share Mr. Buting's opinion of their capabilities of doing this testing? Attorney Gahn, let me put it this way. I share that there has been prior cases, or especially the Cooper case, Mr. Buting, that is in existence, and the National Medical Services, Dr. Ballard, did not fare well. Yes, I agree, and I do not care to send it there. Now, whether there have been, no, I agree. I do not believe that that is an appropriate lab to send it. So, the court. And with respect to the FBI testing, has something changed at the FBI since Mr. Buting indicates that they were criticized in their previous case? Attorney Gahn, I don't know, Your Honor. I don't know that they stopped doing it. I'm not aware of that. When I talk to the FBI, I just do not know that. All I know is that they can test it and they can quantify it. I want to say something else. There are a few differences though, and I know that Dr. Ballard did get beat up in some court, and he did make some stretches and leaps in his conclusions. But as I recall, the cases I read, and they are probably the same that Mr. Buting read. You were talking about he was a defense witness, and they were talking about that blood was on fabrics like a person's shirt. There's a diffusion of that blood throughout the shirt, and it is different to try and determine the volume of what that blood would be, or what the volume of the EDTA in that as compared to the volume of EDTA that's in the blood. I don't ever recall a case that I read where they had an actual purple top tube where they say it's coming from to make a comparison. So that's a difference. The other difference is that according to the records that the defense provided me, Laboratory Corporation of America, 2 days after this blood was drawn by a nurse, made spot cards of it. So that's almost a control that would be very helpful to the interpretation of this case, if that control is still in existence. Now, I have a call out to Laboratory Corporation of America, and I talked to a Megan Clement, and as I said in my brief, there are a lot of questions that we still have to investigate and look at. But if that spot card is available, and then you've got sort of like a control that was taken right before the blood was drawn, and that spot card usually are very fresh. Now, they are free of any type of contaminants, and that's the purpose of them. You could get an EDTA level right there. And the other thing is that we have blood that is on like the vinyl of the car, on metal portion, and good photographs of it. Things like that are isn't any excuses that one could possibly make rational determination of the volume that is there. And that's the difference with this case than the ones where I read where Dr. Ballard, I think, did make some leaps, a few leaps from his fabric evidence, and whether it contained blood that would have come from purple top tube. But we have the tube here. I also believe that if we get, and we could make some type of quantitation. The problem is this: if you look on that Exhibit 3, the defense sent us in their initial brief, the Laboratory Corporation of America, I can't tell whether the removal 1 or 2 milliliters. I don't know what the tube is. This is. I don't know if the nurse drew the full container of the tube. I don't even know the size of the tube. All these questions we're trying to answer, and we have only, and it's been very difficult over Christmas and New Year's holidays finding people. Mostly everyone is operating under a skeletal crew in their offices. We are trying to, which is to contact people that we have known about this back in July. We could have done it, and apparently the defense has not pursued any of that. And I believe that they just like the fact that there is this vial here, there, and they are going to just draw their conclusions and try to get the jury to speculate what all the possibilities could have happened to that vial. We want to get to the truth. We want to test this, and I believe we must test it. The court, and what's your belief indicates that the FBI will require 3 to 4 months. Is that because these tests take that long, or is there some other reason? Attorney Gahn, I think it's a recalibration of their instrumentation. The court, explain that to me. Attorney Gahn, well, from my understanding, that is a very during accreditation, you have to recalibrate all of your instruments that you do whatever your tests are on. They are in a process of doing the recalibration of their instruments. That is my understanding of why it's 3 to 4 months. The court, and do you know whether there's anything that can accelerate that schedule? Do they understand that this case is scheduled to go to trial in a month? Attorney Gahn, yes, I have made that clear as far as, and I asked, and no, they cannot do that within that time frame. The court, all right, what I'm going to do today is take under advisement this weekend the request of the state to adjourn the trial. That's one of the issues that's raised here, and I want you to spend some time to think about that. With respect to the other issue that's raised concerning the frame-up evidence, if you will, I did go back and take a look at my notes from July. And this is one of the cases where I didn't pay enough attention to my own notes. I did indicate in my notes to myself that if there was going to be evidence introduced in support of a frame-up defense, that it should be dealt with by motion in limine ahead of time. At this point, the court has been informed by the defense that the blood vial in the clerk's office would be from the basis, or maybe the key element of a defense the case regarding the alleged frame-up. I don't know whether evidence that defense may be contemplating introducing as part of that defense. And in order to conduct an appropriate analysis under Richardson as to whether such evidence should be admissible, I have to know what it is. We have a motions hearing scheduled for January 19th. What I'm going to order is that the defense provide the court in the form of a motion in limine that whatever evidence it intends to introduce on the issue of a frame-up defense by next Friday, so that I can review that evidence and we can be prepared to deal with the motion on 19th of January. I will, on the issue of the request for an adjournment, get back to the parties early next week. Is there anything else today, keeping in mind we still have, I think we're still going to keep it in the 9 o'clock status conference tomorrow. I want a telephone status conference. I want to just to inventory things that have to be addressed before we proceed on the 19th. Attorney Strain, there's one more thing today. We have tomorrow at the end of the day a deadline on expert disclosure and also Denny disclosure. And I think we can hit the expert disclosure. We could hit the Denny disclosure, but I have lost a lot of time this week because of this issue and an unexpected trip to court, and also because of the cancellation of flight on Tuesday morning back from a weekend away. I would like the opportunity to file by Monday at noon the Denny response rather than by tomorrow at 4:30. I ran that by Mr. Kratz. I'm sure he is not wild about it, but as always, he is courteous, and I think he doesn't have any objections, but of course, that's the court's call. The court, any objection from the state? Attorney Kratz, that's a professional accommodation I'm willing to provide, Judge. Not a problem. The court, all right, that's acceptable to the court. Anything else today? Attorney Kratz, no, not today, Judge. Thank you. The court, very well. We're adjourned for today. Proceedings concluded.